Hello, everyone, and welcome to day 2 of MCIA's India ADR Week. My name is Sanjana Pramod, and I work with DLA Piper. This investment arbitration session is hosted by Alan and Overy and will discuss whether the pendulum is in favor of the investor or the host state. The audience will agree that none of these panelists warrant any introductions. It is nevertheless an absolute honor and a privilege to introduce Mr. Harish Salve, QC, who is one of the world's leading arbitration counsel with a global reputation for treaty arbitration, commercial arbitration, public international litigation, and litigation. Mr. Salve was awarded one of India's highest accolades, the Padma Bhushan, and was appointed Queen's Counsel in 2020. Next up, we have Ms. Fereshte Sethna, who heads DMD Advocates International Litigation and ADR Group, and has over 26 years of experience in arbitration and litigation and a significant experience relating to investment treaties. Mr. Howard Rosen, who is the Managing Director with the Secretariat and has been consistently recommended by key listings as a leading expert with over 39 years of global experience. It is finally my pleasure to introduce ANO's very own speakers, Matthew Hodgson, who is a partner in the Hong Kong office and acts as an arbitrator and counsel under various arbitral rules and has represented investors and states in various treaty arbitrations as well. Finally, we have Sheila Ahuja, who is a partner in ANO's Singapore office and co-chair of Young MCIA Steering Committee. Sheila has extensive experience in investor state and commercial arbitration and associated court matters. I'd also like to invite the participants to post their questions in the Q&A section. This session will be transcribed. Sheila, I leave it to you to take it from here.
Thank you very much, Sanjana, and a good day to everyone who's joined this webinar. I'm delighted to be moderating this session on behalf of Alan and Overy, and also firstly would like to thank the MCIA for organizing the India ADR Week, which we as a firm and I in particular am very grateful to be a part of. I'm even more delighted to be joined by the panel that we've been able to convene. And after those introductions, and even without them, I'm sure the audience will agree with me that I can only say that with the caliber of individuals we have, I'm relieved that I'm the one who only gets to ask the questions, and by no means am I obliged to answer any of them. So the topic we've got is investment arbitration. Is the pendulum in favor of the investor or the host state? The way that I plan to run this is to divide that session. There's a lot that can be said in it, obviously. And what we've done is picked a couple of topics that represent the themes we've been seeing lately or the discussions that have been had around this topic more generally. I'm going to introduce, therefore, 4 subtopics within them. And then what I'll do is play it out, like for those of you who are familiar, a bit of a Karan Johar rapid fire round style, where I will put questions to each of you as panelists. And of course, I get to pick the panelists, so apologies in advance. And I'll leave you to respond. Of course, if other panelists wish to add to any question, then that would make it all the more interactive and I think fun. So without further ado, let me get started. The 4 subtopics we have are, I'm going to deal with the model BIT, India's model BIT, state regulation versus legitimate expectations. Then we'll move on to the role of the discounted cash flow method in making the investor whole in investor treaty claims. And finally, COVID state measures and investment arbitration. So moving quickly to topic 1, India's model BIT. Now, of course, we know that India unveiled this model BIT in 2016, and it's since been the base text for India's negotiations of BITs in the last few years. What we've seen around that is commentators noting that this model BIT significantly limits the protection afforded to investors compared to India's prior BITs, and therefore the conclusion that this must be a reaction to the cases, the significant number of investment treaty claims that India has faced. And for those of you following this closely, you'll know that India has 25 publicly known treaty cases against it that have been commenced to date. So with that very short background, Mr. Salve, sir, if I can call upon you first, and may I just say that I'm going to enjoy this moment of being able to put the tricky questions to you rather than being at the receiving end of them. Can I start by asking you, in your view, what is your take on India's model BIT as it stands? And in particular, which feature to you represents the most significant departure from the world prior to this model BIT?
See, I think we need to coin another acronym. The India model BIT should be called the India UIP, Unilateral Investment Promise. It is unilateral because I don't think anybody has agreed to this kind of a joke. And it's a promise by the government saying, come invest in India, we promise you we are nice people. Vodafone may disagree, Devas may disagree, but that's what it is. It is clearly a reaction, and if you find something strange in Article 2.4.2, which says whether or not something is taxation, it will be left for the government to decide, and which will be non-justiciable. You have Fereshte to blame. So she's responsible for this clause coming into this treaty. And I think the government of India finally, having signed the treaties, came alive to the proposition that a bilateral investment treaty tribunal can make an award against you, notwithstanding a parliamentary legislation or a decision of the Prime Minister's office. Suddenly they had a feeling that the sovereignty of India was being compromised by treaties, which is the noise I've heard in India. And when I was consulted once informally, I said, if you're so protective of your sovereignty, don't sign a treaty. You can't sign a treaty saying, I reiterate my sovereignty and how dare you tell me what I should be doing. So that's what treaties are for, to govern yourself by the platform of international law. So this treaty is clearly a reaction. If you see, FET has been booted out. National treatment has been watered down. The full protection and security has been booted out. All you're left with is expropriation with a major carve out. And basically this treaty says, if you want relief in India, you must go to an Indian court. So that's why I call it a UIP, not a BIT anymore.
And looking at it another way, so on the flip side, India is also, of course, increasingly a capital exporting country. And investments into India have led to the reverse as well, which is publicly known treaty cases brought by Indian investors to date. So, and again, half of these were commenced in the last 5 years. So do you think that if more countries did sign this model BIT, would there be a balance struck between investors and host states adequately to reflect this fact of India becoming a capital exporting country?
I think it would be more straightforward if the government of India came and said, we are a capital exporting country and we don't believe in this BIT culture, and said we don't want BITs, rather than come up with a sad excuse for a bilateral investment treaty like this. If we are so protective and we are so confident and we say have faith in India and come and invest in India, don't sign a treaty. You can and say I'm a capital exporting country. The fallacy of capital exporting is you're confusing the mathematics of a netting off with individual investments being made into India and out of India. There are still sensitive areas where India desperately needs investment and which is not forthcoming because people have question marks. I remember of one case where a very large client came to me and said, what do I do and how do I proceed? And I said, well, if retrospective law is going to be the order of the day, you can keep fighting your case, but it's no use. And that client said, I've got $1 billion lying in a bank account to set up something in India, which India desperately needs. I'm not going to bring that money. So to say that India is a net capital exporting country doesn't really solve your problem. The exports from India, what I have seen, go into developed countries. You really don't need this. It's the capital put into India, which is a noisy democracy. And I mean it in a positive way. We are a noisy democracy. People are assertive. You have a powerful media. Sometimes it goes overboard. So to prevent against populism, you need these kind of treaties. So this capital exporting thing, frankly, I find unconvincing. But if the government of India feels so strongly, they should refuse to sign treaties rather than give this kind of an excuse.
And so I guess one of the features you were describing, one fairly significant feature of the model BIT and fairly controversial feature of the model BIT is this exhaustion of local remedies. It's Article 15, which requires that an investor must pursue local remedies for a period of at least 5 years before it can bring the claim, unless that investor can demonstrate that there are no available domestic legal remedies capable of reasonably providing any relief of the same measure or similar factual matters for which a breach of this treaty is claimed, or of that particular treaty is claimed. So again, this exhaustion of local remedies provision, to give some meaning to the availability of treaty protection to begin with, how do you see, or how do you expect future tribunals would want to interpret or might interpret this proviso of Article 15?
See, by itself, Clause 15 speaks of exhaustion of domestic remedies. When you read it in a context, it creates serious problems. The language which they've used is remedies in respect of the same measure or similar factual matters for which breach of this treaty is claimed. I know what the government of India here is trying to attain. One of the defenses they ran in Vodafone and in the connected case, which is still award is awaited in the Singapore arbitration, Vedanta, PLC, is that there is a constitutional remedy and you can challenge an unconstitutional law. And we tried arguing that Indian constitutional law may or may not provide a remedy. This is a treaty remedy on the touchstone of FET or FPS. And those are not what the Indian constitution provides. The Vodafone award suggests that that argument has been rejected. Obviously, in Kane, they must have argued the same thing. The Kane award is in public domain. The tribunal has not found that persuasive. To get past that, they have added this. So virtually, this will mean all disputes must first go to an Indian court because there is no remedy. There is no measure in respect of which a remedy is not available. If nothing else, on violation of the rule of law in Article 14, everything can be challenged in India. So this will virtually mean your round one is in Indian court. And then they have put in a clause saying the tribunal cannot get into the merits of a judicial review. So if an Indian court has said this is fair and reasonable, then they will tell the tribunal that conclusion is final. So this actually shifts all disputes back into Indian municipal courts. And that's why I call this a unilateral investment promise. This is not a treaty at all in that sense.
And I suppose that just to follow up on that, and it's linked to a question we're being asked, is what does that then mean for the investor into India? Is it actually, if one were to, I guess, pick the choice between the two, is it better, are you just better off having the domestic remedies that would be available to you, taken away the model BIT?
We have domestic remedies, which we have. And if you have, Indian courts are robust. I'm not for a minute saying that the Indian courts are not robust. But having said that, all constitutional principles, all administrative law principles recognize that there has to be a great elbow room for fiscal policy. And if you see the jurisprudence of international treaties and the way international tribunals have understood the fair and equitable treatment clause or the full protection and security clause, it is very different from the way the courts have been more or less hands-off on challenges to economic policy. So for somebody to suggest that the domestic remedy more than adequately, or at least in some measure fills up the gap, is complete, can only be if you don't fully understand what treaty law is all about.
Thank you, sir. And I suppose your point about legitimate expectations and FET standard brings us to the next topic, which is sort of the comparison between state regulation and this right to sort of be protected in respect of your legitimate expectations. So the Fair and Equitable standard, so the Fair and Equitable Treatment Standard, which we call the FET standard, is the most frequently invoked standard in investment disputes. And it tends to be the basis of majority of successful claims pursued in investment arbitration proceedings. It's generally accepted that the dominant feature of the FET standard is that the state must not defeat or frustrate a foreign investor's legitimate expectations, which that investor relied upon at the time its investment was made. So then the question of whether there's been a failure to meet legitimate expectations, how is that to be determined? It ends up being a fact-sensitive exercise, and sort of state measures which in one matter may give rise to a treaty breach may not in another, even if the measures are fairly similar, because it's so fact-sensitive. And it really does also depend on the specific content of the investor's legitimate expectation. So the flexibility of that concept explains why it's so popular on the one hand, but I would say it also raises concerns that it may excessively limit a host state's regulatory powers by by this treaty standard sort of being a wide catch-all provision. And just with that background, Fereshte, if I can ask you, what factors have tribunals found to be particularly important or even not so important in determining whether reliance by a foreign investor on host state conduct is reasonable?
Sheila, thank you. Let me start by saying that principally there are really three areas in which you will test host state conduct. The first is where the host state has executed a document. So for instance, where you have, say, an information memorandum of the type that you saw in Enron versus Argentina, where typically there were certain representations, if you will, held out in an attempt to promote privatization of a state-owned company, which for all intents and purposes was ultimately found capable of being relied upon to effectively push back on what was the specification, as you know, insofar as concerns the dollarized tariffs that were part of the utilities arrangements that were in place in that case. And obviously, as we know, there's that entire body of litigation or arbitration that transpired around that Argentina crisis in the context of the emergency laws of 2002. But that apart, therefore, where there's a document, where there's an express document that could effectively be relied upon, very clearly that by itself does become a matter for host state conduct to be tested upon. On the other hand, you have guarantees or licenses or regulatory frameworks of the nature that would be capable of being treated as immutable. Now, obviously, insofar as immutability is concerned, that would have to be tested on the touchstone of stabilization clauses and obviously a granular read of what it is that the entire framework, as it were, as a whole, were to offer. So whether it be in the form of legislation, read with any regulatory directives, read in consonance with a license, all of that would obviously come together in order to eventually test host state conduct. Again, any number of examples there, starting from Enron, Argentina. But coming then to another category is, and what I consider to be a fairly important one for purposes of your question, is the one where there is a declaration or a promise or an assurance by the host state. And declarations, as we know, from the nuclear tests case of 1974, which essentially pertained to nuclear tests being run, and the ICJ was presented with a case by Australia. And in that context, the ICJ had opportunity to evaluate the apprehensions that arose from measurable quantities of radioactive matter that were found to potentially be dissipated across the world in varying degrees, which would, inter alia, involve a nuclear fallout or the consequences of that radioactive material effectively falling on Australian territory. And it was in that context that the ICJ had the opportunity to weigh up what were declarations made by France to the effect that they would not be continuing those tests otherwise than through underground testing. Now that was held and I consider to be fairly landmark, because that was held to be a unilateral declaration, which was an undertaking given publicly with intent to be bound, erga omnes, therefore available to the world at large, and therefore available to the international community to rely upon. And therefore, the ICJ went on to hold that in circumstances where that type of unilateral declaration is available, then very clearly the state is bound and required to follow the course of conduct that would necessarily be the concomitant or consistent with that declaration, without any requirement for any form of quid pro quo, and obviously relying on the principle of good faith, trust, and confidence, which is inherent to international cooperation. So that, I would think, sums up my views on your question. I wonder if I've answered you fully.
Yes, I think you have, and I think your division of the three categories is very helpful, because of course, as a point of principle, any form of state conduct can in principle give rise to this concept of legitimate expectations. So just building on these three categories in particular, in your view, what are the circumstances where an investor can establish its legitimate expectation based on something like a generic form of a document, I guess, generic category, as opposed to something specific? So I'm thinking sort of on the one hand, laws and regulations more generally, versus what you mentioned in one of your categories, the specific licenses or permits or even a declaration for that particular scenario.
Well, so let's just look back at the recent Spanish renewables cases. I think there's a lot to take away from those, because as we know, legitimate expectation was looked at and was in fact rejected in the case of, say, Stadwerk. Now, the big question is why? What is it that the tribunals considered? What is it that they weighed up? What were the prevalent socioeconomic criterion that they effectively looked at? And how did they eventually conclude that there was, in fact, no legitimate expectation in circumstances where, for all intents and purposes, an illegitimate tariff in the form of a tax is what was principally in contention? What was effectively being argued by the claimant was that in the garb of tax, in the garb of exercise of sovereign right of taxation, Spain had gone ahead and laid a tax, which obviously within the contours of the ECT, the Energy Charter Treaty, was not capable of being laid in circumstances where it effectively would frustrate or defeat their legitimate expectations. And in that context, the tribunal weighed up the very critical criterion, which I believe is possibly going to be the landscape for these types of claims going forward. And obviously we know that there was an annulment proceedings that was brought in respect of Stadwerk, which culminated eventually in a withdrawal of that annulment proceedings, because in the meantime, Spain has brought along a new framework, and obviously with all of the bells and whistles, which included the clear advantage to investors who would not pursue any longer their arbitration claims and or not pursue their damages entitlements if awarded, to obviously switch out into that new framework, as it were. But let's just examine for a moment what were the defenses that were taken by Spain specifically on the issue of legitimate expectation. They were, the first, as to whether or not applicable regulatory framework and its functioning was to the knowledge of the investor. So knowledge, of course, is key to legitimate expectation, coupled with the fact that you should have shown yourself to have relied upon that knowledge in taking your decision to invest. The second, whether the appropriate government authority had in fact made a specific commitment to the investor that the regulation will remain immutable. In other words, therefore, coming back to the issue of immutability, if there is no absolute assurance of the type that would effectively facilitate an investor to contend that under no circumstances would there be any form of change insofar as concerns, whether it be a tariff or a license condition or otherwise, which is, of course, knowing that these are long-term contracts is almost implausible. but nevertheless, so that was obviously the second key defense that Swain took on the issue of legitimate expectation. And the third was whether it would be reasonable or justified if tested on the plank of economic sustainability and on the principle of a reasonable rate of return, that such a tax or tariff or effective variation from where it is that the investment started out should occur. And it was in fact on the finding of the tribunal that there was in fact a reasonable rate of return available to the investors that the tribunal eventually reached its conclusions, amongst, of course, a myriad other things. These are, as you know, very detailed, long awards and plenty beyond what I just mentioned, but yeah.
And what's interesting about your point about knowledge in particular is how put another way, sort of looked at it on what is the duty on the investor to begin with. And Mr. Salve, I may ask you to comment on this as well after you, Fereshte, but what do you think is the duty, or how would you define the scope of the duty for the investor to do its own homework, so to undertake due diligence in respect of their investments, rather than to rely on this standard as sort of an insurance policy, you know, as it's been described, against what's nothing more than a bad business judgment? How does one balance that, and what is that onus on the investor itself?
I think we'll allow Mr. Salve to go first.
No, I would rather you answer that, Fereshte. I have a more generic comment.
Okay, sure. Okay, so let me bring us to the 2019 case of Soles, which again is another of the Spanish renewables cases involving, again, the regime for remuneration of renewable energy providers, where the tribunal concluded that a formal due diligence process is not a precondition to a successful claim for legitimate expectation. Now that, I think, is again a huge departure from where it is that we know due diligence requirements to sit at. And therefore, to knowledge and due diligence, we do have, as recently as 2019, a tribunal finding to the effect that formal due diligence processes are not a precondition to successful claims for legitimate expectation. So what is it that the tribunal looks at? The tribunal says that investors' legitimate expectations must necessarily not be permitted to benefit from gaps in subjective knowledge of the regulatory environment. And in fact, we tested on an objective standard. Because whether or not a regulatory regime is amenable to change, whether or not the host state had an obligation to retain the original or essential features or the core features of what it is that was held out at the time when the investment was made, are matters that a prudent investor may perhaps not necessarily have a full understanding of at the time of the investment. So for instance, when it came to an issue of cap on hours, something as narrow as cap on hours in the realm of the tariff regime, whether or not that was in fact envisaged at the time of the investment, and the level of attention and detail that was paid by the investor at the stage of the due diligence to look at that and effectively take away that that was a immutable term of the arrangement is obviously a factor that a tribunal will take into consideration. And in the fact pattern, the tribunal came to its conclusion that, well, clearly, there was much to be said. So I think given that the levels of due diligence that would typically occur at a time when an investment is made, and as we know, there's all types of advice that is taken, from legal advice, to commercial advice, to techno-economic feasibility advice, to what have you. Ultimately, all of that gets laid out before the tribunal, and a lot of that ultimately has to be carefully navigated, including through the Howards of the world, who would effectively throw in with Harish's fantastic analysis in terms of how you would effectively present all of that eventually. So yeah, I think that is where we sit on the due diligence piece for now. It's really quite open. It differs from case to case, as you just mentioned, Sheila. So that's really where we are.
Thank you, Fereshte. Mr. Salve, you had a general comment.
If I may just pick up on due diligence, I think one of the important elements of treaty law is we have to try and make it as black and white as possible. Because if the treaty law starts getting too much gray and too little black and white, then it will suffer from the same disease it set out to cure. Having said that, due diligence, where there is a plea that there wasn't a sufficient understanding of an existing legal regime, is something I can understand. But I have heard, and Fereshte will bear this out, in two of the cases, we have heard the extreme variants of due diligence arguments. For example, a state arguing, saying you've invested a lot of money in a mining resource. You should have known whenever we give our mines, there's always chaos and you're never likely to get a clear title. Now, is that due diligence? And in that kind, it is to prevent against your normal conduct that you enter into a treaty like this. Or to take the most extreme case, one of the most strongly argued point in the retrospective tax cases in Vodafone, Kane and Vedanta is that when you were investing in India, you should have known India has a terrible culture of retrospectively changing tax laws. Now, when you say you sign an investment treaty, what's the whole purpose? The whole purpose is, yes, I know you have a bad history and that's why you have an investment treaty. And hopefully, to foreign investors, you will not do what you're otherwise known for doing. So, this due diligence sort of runs in circles. But I just wanted to make one comment. See, legitimate expectation, if you take a step back, it started in administrative law. And it actually started with Robertson Minister of Pensions and the High Trees, where Lord Denning brought in the commercial law notion of promissory estoppel into administrative law. And it then got classified as a principle of fairness. And from there, we have now chiseled it into legitimate expectation that you behave the government to honor its commitments. Now that becomes particularly sharpened when it comes to an investment treaty. And invariably you'll say, for example, Ministry of Power will go and conduct a roadshow all over the world saying, come invest in the power sector. Ministry of Telecom will do a roadshow. Ministry of Roads will do a roadshow and come and say, invest. And if those are the representations made, surely it hardly behoves a state to turn around and say, you're right, we said this, but you know what, why did you take us seriously? I mean, that's exactly the kind of approach that the investment treaty is supposed to block. So this legitimate expectation, yes, there are cases and there are awards which we have this lovely expression now called outliers on both sides. But broadly, what tribunals have gone is by the seat of their pants. If you feel that the conduct of a state is unfair, you may put it under FET, you may put it under legitimate expectation, you may put it under any of the heads. And if you feel that given its compelling economic circumstances, what a state has done is not inconsistent with how one would fairly treat a foreign investor, it passes muster.
Yeah, thank you, sir. That's a very helpful sort of way of putting what ultimately the test should come down to, isn't it? And I suppose you both sort of talked about due diligence in a wider sense. I mean, one of the aspects of due diligence that has come up is also in the context of determining whether or not there's a jurisdictional problem. And Matthew, I wondered whether you wanted to comment on that aspect of due diligence. And I should warn Howard that I am coming to you next.
Thank you, Sheila. Yes, I mean, we all know that where there is serious illegality in the making of an investment, such as fraud or corruption, a tribunal will generally conclude that it doesn't have jurisdiction or the claims are inadmissible. But more nuanced are the situations where there has been another breach of local laws in the making of an investment, which may be less serious. It's non-trivial, but it may be less serious. Question marks over whether the person who signed a contract for on the government side had the requisite authority, for instance, or other local law breaches. And the question has sometimes come up in that context whether an investor's due diligence is relevant. And there were a couple of the earlier cases which come to mind of Inmerus in Ukraine and Kardasopoulos or Georgia, where the tribunal didn't actually go into that question of investors' due diligence. They said, well, you were dealing with the state. Firstly, you're entitled to consider that the state officials are acting consistent with their own law. Governments can't plead their own breaches of domestic law in defence of breach of an international obligation, or else they're stopped from doing so. So they looked at it that way. Slightly different was the decision in Anderson and Costa Rica, where a number of investors found themselves innocently caught up in what was essentially a Ponzi scheme, which was shut down by the authorities, and they lost their deposits. And when they sought to recover them through a treaty claim, the tribunal said, well, no, those investments were made in breach of laws regarding the use of financial intermediaries, even though there was certainly no question of any serious wrongdoing by the claimants. They had not carried out the proper due diligence as to the local law requirements in that regard. And in the end, the tribunal didn't have jurisdiction. And I found that was quite an interesting development in the case law, and it will be interesting to see if further tribunals examine that and consider whether in cases where there is arguably a serious breach of domestic law, the investors' due diligence becomes a relevant consideration.
Thanks, Matthew. We've talked about the jurisdictional aspect. Of course, all along, we've also been talking about liability. Let's move on, I think, to damages. So, of course, the next topic is the role of this discounted cash flow method in making the investor whole again, if it, of course, prevails on liability. So despite this wide adoption of the DCF method in calculating damages, there is a lot of controversy in its use, in particular where the enterprise in question lacks a proven record of profitability. It's then said as, why is DCF still the right way? Why should it get damages by way of the DCF method? The recent October 2020 Quantum Award in the Davis in India decision is a good illustration of this, where the majority in Davis awarded more than $111 million by adopting the DCF method, despite the fact that the company in the telecom sector had no historic operational activity. Of course, I also note that the dissenting arbitrator rejected the application of the DCF model and favored awarding sunk costs instead. So I have specific questions on this, but Howard, I wonder whether you wanted to, for those of us who are, I know some of us here are very familiar with this decision, but for those in the audience who are less familiar, if you can give us a little bit of an overview before I give you my rapid fire questions.
Thank you very much. I mean, I read the decision and the dissent, and it requires rereading several times. It is a very rich content award and dissent. It's a very, very important issue for quantum experts and for claimants and respondents alike. The approach taken by the majority looked at sort of the compensatory aspect of damages and said, we've arrived at a decision. We're going to compensate them for the taking of this asset. The various factors they considered not important at this point. But what they arrived at that point in the decision was claimant had put forward an argument that once you make the decision that we have to be compensated, whether it's a chorzo or fair market value compensatory relief to put you back in the position you would have been to make you whole, then it becomes a question of economics and valuation. And so the tribunal, the majority in that case, looked at other cases and looked at the very fact-specific situation in this case and determined in their view, based on the facts as argued, that they could adopt the DCF. And they made that decision. The dissenting opinion took a slightly different point of view and used a more legal principled approach and cited principally, I think, 3 buckets of support for the dissent. The first being that there's lots of other tribunals in other cases that have been faced with DCFs for early stage companies, pre-revenue companies, and the majority of them have found that it is not appropriate to apply DCF. The second thing that the dissenter relied on was two previous cases, the ICC and the DT tribunals in related telecoms cases, and said they also found that it was not appropriate to use a DCF, so he relied on that aspect. And the third was reference to a World Bank document that outlined, from a legal principle point of view, gave some guidance on approaches to compensation for early stage companies, or at least companies that are pre-revenue, and referred to those as not a going concern. And so you have the majority looking at something fact specific, and it was like your FET discussion, something that is fact specific. And then the dissenter looking at something that is more legal principled. And it's really, again, I think there will be lots written about this award and this dissent. The cases cited, I've been fortunate, I was not involved in this case, but I've been fortunate enough to be involved in a lot of the cases that were cited in both the award and the dissent. And so I have some very definite opinions on the use and misuse of DCFs. So with that background, I invite your questions.
Thank you. I was going to take you on that last comment there on your opinions of the two divergent approaches, both of which I think you explained, at least on its face, appear to have very legitimate basis. So in your view, or at least your take of this, what are the factors that you have found, of the cases you've been involved in, or more generally, just from your experience, that tribunals have found to be relevant in determining whether the DCF method should be adopted? What have tribunals found, and what do you think, are the factors that really should lean towards the DCF method being adopted?
Right, and again, I think the factors that were outlined in the dissent are frequently cited by respondents, and it's a safe place to go because it is a legal principled approach. And I find a lot of tribunals find comfort in that because they are not valuation experts, and it is difficult to engage with the evidence. That's why I think the Davis Award is really important, the majority, because they do engage at a microscopic level with a lot of very, very difficult issues. And not commenting on whether the award or the dissent is something that I would prefer, because again, I wasn't involved in the case, so I don't have a preference for one over the other. But I think it is a very fact-specific situation. It cannot be that every pre-revenue company, excuse me, or every revenue positive company has a particular way of valuing it. I think tribunals are mostly guided by the market. And that's the kind of evidence that I find tribunals find compelling. I think they are suspicious of black box models, of party appointed experts who have widely divergent views. And I think rightfully so, they are suspicious of any of these models that are created that are highly sensitive and not reconciled to some measure in the marketplace. So when I'm speaking to tribunals, I find when they engage in this evidence, they are most keenly interested in, how does this relate to the real world? How would these transactions be done by actual parties as opposed to hypothetical parties? What have you looked at in the marketplace to try and reconcile your views, whether to use a DCF or not use a DCF, with the way actual market participants transact? And I think if the damages experts keep that view in mind, I think they'll find the tribunals engage much more directly with them and much more fruitfully.
Thank you, Howard. And just picking up on your point about how, relying on sort of market or actual factors and market related factors. So talking about early stage companies, if you have an early stage company and you're relying on a DCF calculation, what are factors that could be relied upon in that situation, in your view?
Right. I mean, in theory, we could all sit together and produce a projection for, we could make up a business after this conference is over, and we can make up a projection and we could apply a very high discount rate to it, and we would all come up with a positive value. And whether the idea had merit or not, every MBA class was involved in producing a model that gave you a value. And so the exercise of going through and doing the DCF is in and of itself not of value. It is the inputs that into that model. And so if you are an early stage company and you are interested in putting forth a DCF, the first thing is, in your industry, at your stage of development, the risks you are facing, is it appropriate? Is that the way actual market participants would view your company? And that's the threshold question that has to be answered. There are some wonderful companies that are extremely valuable, but because the two obvious inputs to a DCF are the projections of cash flows, and they have to be reasonably determinable, number one, not in the eyes of the tribunal or the eyes of the law. They have to be reasonably determinable by people who invest in these types of companies. And I think that's what the majority found compelling in Davis, is that the model they referred to and the inputs into that model were things that sophisticated investors were typically relying on. So if you're a natural resource company, you're a serial startup. Every time you put a hole in the ground to dig for something or drill for something, there's an expectation based on the commodity you're looking for that there's going to be success or failure depending on the stage you get to. And there are rules that help guide valuation professionals as to when to use a DCF. Once you cross a threshold of knowledge and have sufficient clarity what those cash flows will look like and can apply a sensible discount rate, you cross that threshold and you can use a DCF. So depending on the business, depending on your ability to reasonably predict cash flows, and depending on how the market views those businesses, early stage companies, again, it's going to be very, very fact specific.
Thank you. That sounds a sort of fair way of looking at it, doesn't it? One comment you made earlier about tribunals sometimes being met with experts who have widely diverging views. So of course, even where DCF is adopted by both sides experts, their calculations and how the model plays out may have very significant discrepancies, and the ultimate number may be very different. So what should a tribunal do in that circumstance? As you say, their ability to engage with the minutiae of the valuation exercise will vary. So what can it do? What should it do?
Yeah, I mean, the last thing you want is on the last day of the hearing, typically when damages experts are appearing and everybody's thinking about their schedule and their post hearing briefs. The last thing you want to do is have two damages experts debate about things like beta and leverage and complicated valuation theory in front of a tribunal. They don't have the appetite for it. And so in my experience, the thing that's been most helpful is when tribunals are more proactive in forcing experts to get together to do a joint expert report. And at least, and the format I use is very, very simple. And I think a lot of experts use a very similar format, is you just list all the major inputs into your calculations, into your opinions, side by side. And where you find you have agreement, you can strike those off. And where you find you have disagreement, but it doesn't have a huge impact on the quantum itself, you can sort of put those in a separate category. And you really want to focus the tribunal on where you have significant differences. If you can narrow it down to 2 or 3 or 4 issues, then you can have a meaningful discussion. You may have witness conferencing if the tribunal wants to engage the experts. If there's one issue where you're just miles apart. So for instance, in Davis, there was an issue whether the projections were done on a nominal or real basis. Now that's not something that you want to debate in cross-examination. You don't want to cross-examine me on that, and your counterpart doesn't want to cross-examine the other expert on that. That should have been an issue that the experts could have done together in a joint report that would have made the evidentiary part of it much easier. But again, the tribunal weighed in. They looked at the evidence. There's a thorough discussion in the award. It was quite impressive what they did in terms of engaging with that issue as opposed to ignoring it. Again, in my experience, a more proactive tribunal that ensures the instructions to the experts are responsive to each other, that there's an opportunity to narrow the issues through joint expert reports, and the use of hot tubs where you've got significant differences between experts and can put it to them and let them speak to each other. I think that's very, very helpful for a tribunal.
Thank you, Howard. I've got one more question actually from the audience, and then I'll move on swiftly to our final topic. I thought this was quite a good question. It relates to what you were talking about before in terms of looking at, you know, the market position on a particular type of business. And the question is about, would that DCF application favor certain types of businesses, let's say sort of mining companies, as opposed to, say, other businesses like social media or gaming companies? So is it also a sector-specific level of confidence when you're—
Yeah, very, very much. So, I mean, I do a lot of natural resource work. I do a lot of mining and oil and gas work. And so, you know what the commodity is. There's views in the market what the commodity is going to sell for. There's fairly good views and engineering reports that'll tell you what it costs to get out of the ground. And there's usually offtake agreements or markets where it's readily available. And so most of the elements for a DCF are fairly objectively determinable. And then it's consideration of things like country risk and how it's financed. And so that's where valuation experts may depart. For things like social media or high-tech businesses or other businesses that don't produce cash flow, so we have many valuable billion-dollar valuation unicorn companies that have no cash flow, that are negative cash flow, but yet they're worth billions of dollars. So you would not use a DCF. Although there are DCF models for some of these businesses that project the eventual turnaround. In the future, they will have such market share and such market dominance, they will have enormous value. And you look at companies like Tesla and other companies with emerging technologies that have, you know, they're some of the most valuable companies in the world. They dwarf companies that have stable historical cash flows, yet they're currently not profitable. And so there are market assumptions with respect to growth and profitability. You think about Facebook in the early years, it was a losing company. It was a money-losing company for years and years and years until it wasn't. And the investors were paid off handsomely. So it requires a different approach. I think tribunals should rightly be suspicious of companies that are projected to lose money for 20 or 30 years and suddenly make money, and all the value is off in the future, because the one thing we know is change is constant and that risk is indeterminable out that far. But there's other ways of looking at it. And so as long as, again, you have market participants that are buying and selling these companies, you have analysts following these companies that form views and help inform market participants on value. And so, again, you have to be specific to the industry.
Thank you, Howard. And just, sorry, before I do move on, Mr. Salve, I guess within confines, because I know there may be some matters you may not wish to comment on, but is there anything you want to say about that topic before?
You know, Davis is a very, I don't want to comment on the majority and the minority, and I think Rosen has picked it up with such clarity. But there's only one interesting spin which you should know, which was the real problem which we had in the Davis case. Normally, if you are valuing a telecom company, you would say, if I go into telecom, if I set up a mobile telecom business, applying the growth rates, this is what would happen. I would have so many 100,000 customers and at this growth rate and approximately this, et cetera, et cetera. You have all the predictions. Davis's contract with the government of India was for a satellite. And from that satellite, their original project was they would give a handheld device, which you could use A, for GPS on cars, B, GPS in trains, et cetera, to see movies. But that was not what the valuation was based on. The Davis valuation was based on the fact that the 3 or 4 American investors, 2 of them of Indian origin, were actually the people who have driven the telecom revolution. And they had found a way of refarming the spectrum. So because of the satellite contract with Israel, a band of spectrum would be made available to Davis. And they claimed that they would be able to refarm that spectrum and provide broadband. And you know, today all telephony is broadband. Now that gives a complete different dimension to a business. What is the probability that they would have been allowed to do a broadband? What would have been the figures of that broadband? This is not what Davis was set up for. Davis was set up for satellite-related businesses. But the turnaround of the refarming of the spectrum is really what lent value, and that is what so complicated the valuation in Davis.
No, thank you. That's interesting, and often, as you say, it is a very subjective. I guess the one theme is all these points just do end up being so fact specific, don't they? And speaking of fact-specific scenarios, that does bring me to my last topic, and I'm not sure you can get away these days with any talk without mentioning the C word, COVID. So just quickly to you, Matthew, what types of COVID-related claims do we expect to see? I mean, there have been rumors and discussions being floated about it. There have even been some threats. But what types of treaty claims do you think that we should see sort of in the horizon in the light of COVID?
I think there are sort of two main categories to keep in mind. The first are the claims that might result from immediate actions in response to the COVID crisis, the immediate public health measures and the immediate economic response that governments have taken. Those cases may come out of restrictions on exports of medical equipment, vaccines, for instance, suspensions of loan repayments, discriminatory treatment in respect of state aid or loans states have made to businesses. But that category, I suspect, will be fairly limited. To date, as you mentioned, there have been a number of threatened claims, at least. I'm not aware of one that has yet gone through to actual proceedings. They are mostly in Latin America, and a number of the measures complained of have no obvious connection with the COVID crisis, and the investors' position appears to be that COVID is simply a pretext for the actions which are being taken. So that includes, for instance, the suspension of highway tolls in Peru, changes to guidelines for electricity grid in Mexico, matters that aren't obviously sort of motivated by a direct response to COVID. But the second category, and I suspect the more substantial number of disputes will relate to what happens after the crisis. We all know that states' balance sheets have taken an incredible hit from the pandemic and state actions in response to it. The IMF has issued a number of warnings about state budgets, particularly in developing states. And what we've seen, of course, in financial crises in the past, both localized crises such as Argentina, as Fereshte mentioned already in 2001, 2002, and also global financial crisis in 2008, we have seen a number of investment treaty claims come out of those crises because of the actions that governments take in response to them, which can include at the extreme end of the scale, nationalizations or discriminatory taxes or other mistreatment of foreign investors who may be an easy target. And I know anecdotally that is something that multinationals are concerned about. I have one client now who has been reviewing the investment treaty protections they've got in place across Asia Pacific in particular, because they're concerned that as a foreign investor with generally good balance sheets, they may be an easy target in a couple of years' time when states look to plug the gap on their balance sheet. So I think those really are the two main categories you can expect.
And Matthew, what would be the defenses then that a state may rely on in response? So far, we've been thinking about the angle of the investor and how they can articulate their claim and what might they face. But what will the state say if, you know, met with a claim that is clearly, I guess, or in some cases not so clearly, but somehow triggered as a result of COVID?
So, well, they will only need a defense if there is wrongful conduct in the first place, of course. And the first question and the first line of defense for a state will be that we have a right to regulate. And as Fereshte covered already, that is, you know, there are certain limits on that, but a state does, as a starting point, have a general regulatory room, as you would expect. So unless if actions are taken for a bona fide purpose for public health protection, for instance, and those are non-discriminatory and non-arbitrary, it may be a challenge for an investor to show there's a breach of the treaty in the first place. But if there is prima facie a breach, then potentially defences kick in. And those include the customary international law defences, most importantly, I think necessity, but also potentially force majeure or distress. There may be a specific carve out in the treaty, as there are in many treaties, including the Indian model BIT at Article 32, which actually carves out certain measures, including those taken for public health reasons from wrongful conduct. But just looking briefly at those defences, necessity was litigated a number of times in the Argentinian context. There are essentially three aspects to it. You need to the state will need to show that it acted to safeguard an essential interest against grave and imminent peril, and that the action they took was the only way of safeguarding that essential interest. And so, as you can probably surmise, the first two of those elements, safeguarding essential interest against grave and imminent peril, may be satisfied in the context of the COVID crisis. The last one, that this was the only way of safeguarding that essential interest, may well prove more challenging, because if there are a range of legitimate policy responses available, then an investor may be able to defeat the defense. And that was, of course, what happened in the case of CMS and Argentina. Even though the facts were relatively extreme, there had been significant civil unrest in response to the financial crisis. The tribunal concluded that actually the devaluation of the peso, a very substantial devaluation, was not the only policy response available, and they rejected the necessity defense. It was also, I think, relevant, as there were separate findings. The tribunal held that actually Argentina had contributed to that situation because the seeds of the economic crisis lay in crises in the past to which the government had itself contributed. So arguably its decision was influenced by the feeling that Argentina itself had had some responsibility for bringing about the circumstances, and states may try to distinguish their response to COVID on that basis. But that's necessity. And then just to complete the picture on force majeure, there are a number of requirements there, but I think the one that's likely to be most challenging for states is that it must be materially impossible to perform the relevant obligation as a result of the external event. So there is no sort of wiggle room on policy there. Essentially, it's an involuntary choice. The state has no alternative. So force majeure, again, likely to be a high threshold.
Thanks, Matthew. And I guess, and I'm afraid this may be our last question, but I'll ask you, Matthew, and then may ask the others to comment. Let's go back to the beginning, which is the draft or the text of investment treaties. So how do you think the COVID pandemic experience will, or do you think it will at all, influence the drafting of treaties going forward?
I think it's likely to be taken into account in future negotiations. I mean, there was already a very clear shift to treaties becoming ever more complex and ever more carved outs and qualifications. One of them, as I already mentioned, is the sort of general exception, making clear that measures which are not arbitrary or discriminatory in pursuit of public health objectives, for instance, will not breach a treaty. That was lifted from GATT practice under trade law, Article 20 of the GATT, and it has been amended in different versions of investment treaties. There's a question how much that really adds actually to a tribunal's analysis as to whether something constitutes a breach of treaty in the first place, because tribunals have repeatedly confirmed there is a right to regulate, irrespective of whether you have this kind of exception. But I suspect they will continue to be included in treaties. Another approach is to qualify the substantive standards of protections to try to clarify what is not covered. Particularly, for instance, the standard of expropriation. It's quite common now for a treaty to contain an annex clarifying for avoidance of doubt that indirect expropriation doesn't mean any regulatory act which happens to destroy the value of an investment. Again, I think that type of language is likely to continue to proliferate. And then finally, and this one, I think more a theoretical possibility at this stage, it's not beyond the realms of possibility that states might seek to amend their existing treaties with some kind of COVID exception. There have been circumstances where states have done that before. After the Philip Morris and Australia case, you saw Australia and Singapore agree an amendment to their FTA to carve out claims coming from tobacco legislation. There have been noises around whether there should be COVID-related treaty claims at all, including from the Columbia Centre of Sustainable Investment. So it's a possibility that some states will seek, by amendment of the treaty, to carve out certain COVID claims.
Mr. Salve, Fereshte, do you have any views on that last question and what impact COVID will have on the? I'm going to ask Mr. Salve about the model. Will there be a new model BIT or an amended version?
No, see, the problem is as follows, as Matthew very rightly said. There are a number of defenses, and if you take a step back and look at it more globally, barring a few outlandish awards, which you call outliers, broadly tribunals have recognized problems of states and have always accommodated states' genuine compulsions. I don't think any country has been spared the ravages of COVID. And I think it would be a particularly insensitive tribunal which does not recognize what states have had to do. Secondly, there is no measure by which one could gauge the reaction of a state. Economic crises are things which the world has seen before. And you can broadly have a cutoff line at which you realize that a state is doing something which really is not connected with an economic crisis or a devaluation or a crash in its economy, and it's using it as a ruse to expropriate foreign investments. The thing about COVID is, honestly, very few states knew what they were doing, and I don't know how much of it we know even today, and heads of states have admitted that they are in a situation which is unprecedented, a situation, the enormity of which nobody has been able to understand. So if there have been measures taken which can broadly be correlated to genuine concerns of COVID, I'm sure tribunals will not give awards. And if they do, it may prompt revision of treaties. But there's something else which worries, which is very important. There is a degree of insularity which is coming into countries post-COVID, especially when the vaccine wars have started. I've just got a message somewhere saying AstraZeneca has given a notice to the Indian manufacturer now. The Indian manufacturer's problem is he's not allowed to export vaccine. Now, these at some point may become treaty claims if there are international cross-border investments, and the vaccine wars, if they really take off as the doomsday scenario suggests, may raise their own problems. And there is a degree of insularity coming into countries because this is such an emotive topic that you cannot inoculate your own country. Why are you talking of free trade? And coupled together with the fact that today, and this is not my subject, but this is what I've read, there is so much capital available. Somebody gave a figure of 18 or 19 trillion or 17 trillion of capital available at virtually no interest rates. And that is why economies are picking up despite the COVID downtrend. The Indian economy is picking up despite the COVID downtrend. So large availability of capital and these kind of a growing sense of nationalism everywhere, need to protect your own borders, may create the right emotional backdrop for revisiting investment treaties. So let's see, watch the space, as they say.
Thank you, sir. Fereshte, I don't know whether you had anything to add. I think we've got a minute before we need to wrap up with apologies, but I don't know whether you had anything to add to that.
Let me just use two words. I think public interest, that is what is going to effectively be key to determining whether or not a state was entitled to act in the manner in which it did. I think that is going to be a very critical area that we have to watch for. Again, for want of time, I won't expand on that.
Thank you. All I can say is that there might need to be a sequel to this session at some point as we see how it all turns out. But in the meantime, what I can say is thank you all so much for your invaluable comments. I don't know about the audience, but I certainly scribbled down a lot of knowledge that I've acquired through this session. So thank you very much for your insights and for taking the time to engage with me on this topic.
That wraps up on an excellent session. and gives us a lot of food for thought. A big thanks to all the panelists and to Sheila for brilliantly moderating the panel on a very difficult and interesting topic. And thank you to the audience for all their enthusiasm and questions. Before we drop off, the last session for the day, which is also on investment arbitration, is hosted by the ICSID and starts at 6 p.m. IST. So if you have any questions that could not be answered, I suggest you ask in the next session. So stay tuned and log in. Thank you very much for your time.